For others, the courts in many states will support you, even if you use deadly force. But today, Florida's Supreme Court is hearing a case that could spell some really big changes for the highly controversial Stand Your Ground law, a law that gained national attention in the shooting death of the unarmed teenager Trayvon Martin. Of course, a jury last year cleared that George Zimmerman of all charges in the killing. Zimmerman's lawyers never actually asked for the Stand Your Ground defense, but it became a major topic leading up to and during the trial. The idea here is essentially this: if you feel like your life's in danger or the lives of others around you are in danger, you have a right to use force even if it's deadly. You do not have to retreat. You can kill. If a judge agrees that you lawfully stood your ground, you get immunity and do not have to even stand trial. In this case, a man from Indiana claims that he was protecting his family back in the year 2011 when he pulled a gun on another driver during a road rage incident. Nobody fired a single shot, but the judge denied the man's request for immunity. He's now appealing that decision. His lawyers claim it should not be on the defendants to prove they were standing their ground. Instead, they say the burden should be on the prosecutors. At least 33 states have Stand Your Ground laws on the books, but the requirements are not the same in every state. So let's turn to a lawyer. Mercedes Colvin is a Fox News legal analyst and friend of the program. Stand Your Ground's very, very, very controversial until there's somebody up in your house about to do something to your people. It's not very controversial then. And
then you say to yourself, wait a minute, I have to protect myself or my family, I'm going to shoot to kill.
That's easy.
But that's an easy one. Here, the law is a little different, though, and it is true. It changes from state to state. Right now, Florida has it as it stands, that if you're coming forward and saying, I stood my ground because I honestly believed I was in jeopardy, myself or my family, that's fine. But now what the lawyers want to do is they want to shift it to the prosecutor. The prosecutor already has a huge burden on its heels. The prosecutor has to show beyond a reasonable doubt that you committed a crime, or in this case, that your homicide or your assault was not justified in any way. That's a big burden. You already have those protections. The only entity that really has immunity is the government. The government can step forward and say, I have the presumption of immunity. You have to show somehow that I was arbitrary or that I violated your Constitution before you can step in and say it was violated.
When I first heard about this, that this burden would have to be, think of what that means, that if you stood your ground, it's the prosecutors have to prove you didn't, right? Which sounds sort of quackery until you read through the law and say, well, he might have a case, and a judge seems to believe he might, and that's why they're going to go through the process.
They're going to go through that process, but that's because it's really a close call here. But it's all about subjective thinking. How can I decide myself what you're thinking at this moment, or you're thinking, God forbid, that you're in a life or death situation, and you have to pull your gun and make sure that that's something that you protect yourself or your family. It's so subjective and so difficult to shift that burden then to the prosecutor to say not only do you have to prove beyond a reasonable doubt, but now you have to really go into the mind of the individual that was holding that gun and somehow just saying that they weren't legitimate when they pull the trigger. It's very difficult. It's best if you're coming forward and say, look, I did this. I have that subjective belief. I truly believed it was reasonable. This is why. It seems more plausible, and frankly, it's more safe for the public to have that type of subjective thinking rest on the individual that wants to assert that defense.
Of course, many would say that this law has no place in America because if you can retreat, you should retreat. That's the position of those who are against this law. If I can run out of here and save my butt, I ought to do that before I shoot and kill somebody.
But if you, honestly,
I'm just saying that,
frankly,
that's what the detractors of this law are. That's the argument that they're making.
And how many of those detractors have actually had that life or death situation on their hands?
It's not my argument.
Right,
it's the argument of those who feel this way about this law.
But that's the thing. All of these individuals that have this, those that have been found not guilty of it or that stood their ground and they found immunity, they truly believe that. And those circumstances led those who were looking at it, whether the judge or the jury, to determine that they were legitimate when they had to shoot and kill. Or in that just pull their gun out and threaten someone.
But in this case, the prosecutor with the burden, even though no shot was ever fired.
I know, which is odd. The fact, but it really is because the driver, the road rage, not the gun wielder, but the other one, went back to his car. That's probably why the judge said, if the guy that you felt that was so threatening to you and your family goes back to their car, why do you think you have to pull your gun out anyway? Yeah. There was already retreat on their side, so what are you doing? That's why it was such a close call.
Well, it's a case out of Florida again, and once we get a decision on it, we'll let them know. Good to see you.
Sounds great. Great to see you.
Thank you.